Hello and welcome to this latest video on King's Chamber's Planning YouTube channel. I just want to talk about very quickly the Court of Appeal's very recent decision that has clarified the way in which Aarhus cost caps apply. I can't take any credit for this case, I wasn't even in it, let alone won it, but it just strikes me as a very important, if straightforward, point of clarification about the cost caps regime. It's the case of the Crown on the application of Friends of the Earth Limited against the Secretary of State for Transport. Its citation is 2021 EWCA Civ 13, and it's a spin-off cost litigation arising from the Court of Appeal proceedings in relation to Friends of the Earth's challenge to the Heathrow National Policy Statement. Obviously the case has since been heard by the Supreme Court, where Heathrow Airport was successful, but this case is about the cost consequences of Friends of the Earth winning against the Secretary of State in the Court of Appeal. It's a very brief, punchy 9-page judgment which deals with a short but important point for anybody who's dealing with claims where the Aarhus cost caps apply. The Court of Appeal had made an order that provided that the Secretary of State was to pay the claimant's costs subject to detailed assessment and a cap of £35,000 in respect of each of the proceedings in the Divisional Court and in the Court of Appeal. And the question that arose was, were those £35,000 caps inclusive of VAT or plus VAT? Those caps had been imposed by CPR 45.43 and CPR 52.19 on the basis that the claim fell within the scope of the Aarhus Convention, which wasn't in dispute. And those rules specify the sums for the caps, subject to them being varied, which are simply expressed as figures with no reference to VAT in them at all. The Friends of the Earth argued that the cap meant £35,000 plus VAT, and they did so for three reasons. Firstly, they pointed to the purposes of the Aarhus Convention and the need to ensure that access to justice was not prohibitively expensive, and they said that aim would be better served if the cap was to be exclusive of VAT, because otherwise if a receiving party was liable to pay VAT on costs, and if their costs without VAT exceeded the cap, then that party would be out of pocket. Secondly, they pointed to case law which they said supported the proposition that the cost cap was to be exclusive of VAT unless the contrary is provided. That case was the case called the Crown on the application of Worley versus Wealden District Council, 2011 EWCA 2083 admin, a decision of Mr Rabinder Singh QC as he then was. It was a judicial review claim relating to a grant of planning permission. There was a cost cap which had been imposed by way of a protective costs order. It was silent on VAT, and the deputy judge decided to vary the PCO to expressly refer to the cap being exclusive of VAT, and he said that was because VAT ought in principle to be recoverable from the paying party. And that decision has been followed as recently as last year by Mr Justice Dove in a case called Abbots Kerswell Parish Council versus the Secretary of State for Housing, Communities and Local Government, 2020 EWCA 2870 admin. Thirdly and finally, the Friends of the Earth pointed to analogies, they said, which existed with the position in Northern Ireland where cost caps were said to be exclusive of VAT. On the other hand, the Secretary of State argued that the cost cap should be inclusive of VAT, and they pointed to the following points. First of all, they pointed to the consultation document that had led to the cost caps being introduced into the CPR. That consultation response recognised that there had been concerns about a proposed cap of then £30,000 for successful claimants, quotes, because it will be subject to VAT, and for that reason they had proposed to increase the cap to £35,000. Secondly, the Secretary of State pointed to what they said was the clear words of CPR 45.43, which just specifies a particular maximum figure, which they said was clearly a total inclusive figure. Thirdly, they said that there was an analogy with the way in which CPR deals with patent cases. CPR 4531 specifies cost caps in patents cases, similarly without reference to VAT, and case law in the patents jurisdiction had decided that those figures were inclusive of VAT. And fourthly, the Secretary of State argued that the Worley case had not been the subject of full argument. It was based on oral exchanges at the end of an extempore judgment. So in that context, what did the Court of Appeal decide? Well, they decided that they had to approach this by first principles, by construing CPR 4543, not cases on other provisions or cases which predated that provision coming into the CPR. Worley had not been a case about construing the CPR because it predated it. Secondly, they said there was no case law which was truly on point, therefore, and so they interpreted the provision for themselves. And they decided that the caps in the Aarhus provisions are inclusive of VAT. There were 4 reasons for that. Firstly, that was the natural meaning of the words that were used in the CPR, which specify absolute sums without any qualification. Secondly, they accepted the point about the consultation exercise, and the history of that supported the conclusion that the caps were to be inclusive of VAT. Third, they said that the interpretation didn't frustrate the Aarhus Convention's aims. The Convention did not mandate what sum any cost cap should be, simply that the costs of access to court should not be prohibitively expensive, and left it to states to decide what that actually meant in practice. And fourth, they said that the Northern Ireland regulations were of no help because they were drafted differently in a way that made express reference to VAT. So the upshot of all of that is that the cost caps in the Aarhus provisions are inclusive of VAT, and that those caps represent the total sum that the paying party will have to part with. The case gives welcome clarity on an issue which has caused debate in some cases. I've had it in cases that I've been involved with where we've all had to try and grapple with what the provision meant. We've now got a clear answer, useful clarification, which of course is always welcome. Thanks for watching. Bye.